Good day, Crime Talk aficionados. The judge in the Bryan Kohberger matter is facing the most difficult decision of his career. Sarah Boone gets her 9th attorney to represent her and then complains she can't get a continuance. Was there jury misconduct in the Ashley Benefield case? Well, her attorneys believe so, and they want a new trial. Robert Tellis convicts himself by his own testimony. And remember that judge jumper? Guess what? We have an update. He has a trial date. And finally, our dumb criminal of the day. Let's talk about it.
Hi, lawyer.
Good day, everyone. Thanks for joining us. My name is Scott Reich, and this is Crime Talk. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell for notifications. And remember, you can check us out anytime on any of your favorite podcasting apps. Now, it is Tuesday. I hope you all had a wonderful Labor Day weekend. I certainly had a wonderful time. We'll talk about that a little more this evening on our live program. That's right. It's Tuesday, which means it's Tuesday Night Live. And tonight we have a treat, I do believe. We're going to have a guest. That's right. Mark Carlson, one of the investigators that I use in my daily practice. Well, he's going to come join us for a conversation, a little food, and, well, maybe even a fine cigar out at the airplane hangar. So join us 6 p.m. Mountain Time tonight.
As a pet owner, you want to give your furry friend the very best. That's why Baked in Colorado's CBD-infused dog treats are the perfect choice. These delicious treats not only taste great, but they also provide a wide range of health benefits for your pet. CBD has been shown to have many positive effects on dogs, including reducing anxiety, alleviating pain and inflammation, and improving overall wellness. Baked in Colorado's treats are infused with premium, full-spectrum CBD oil, meaning your pet will benefit from the whole plant extract. Not only that, but Baked in Colorado's treats are made with all-natural human-grade ingredients, so you can feel good about what you're giving your pet. They're also free from wheat, corn, and soy, making them a great option for dogs with food sensitivities. Baked in Colorado CBD-infused dog treats are the perfect way to support your pet's health and well-being. With various flavors, including peanut butter, pumpkin, and bacon, your dog will love them too. So why wait? Head to www.bakedincolorado.com today and order your dog a bag of these delicious and nutritious treats. Your pet will thank you for it.
All right, let's go ahead and get to the docket. Let's open the record for September 3rd, 2024. First, the Bryan Kohberger matter. The judge in the case of Bryan Kohberger says that he is facing a challenging decision regarding the venue of the trial of Bryan Kohberger, who is obviously accused of fatally stabbing 4 University of Idaho students back in November of 2022. Now, the judge, whose last name is Judge John C. Judge, is contemplating whether to move the trial about 300 miles away to Ada County, which is Boise, to assure a fair trial. Now, during a hearing back on August 29th, the judge acknowledged the weight of the decision, stating, quote, "This is probably professionally the most difficult decision I've ever had to make." The judge is considering the arguments presented by both the defense and the prosecution before making his ruling. Now, the murder of Kaylee Gonzalez, Madison Mogan, Zana Kernodle, and Ethan Chapin obviously shocked the community and led to a 6-week manhunt of Bryan Kohberger, who is the prime suspect in the case. Now, Kohberger was arrested back in December of 2022, and after entering pleas of not guilty in 2023, Kohberger has a trial set to begin next June. Now, what is the argument for the change of venue? Well, Kohberger's defense team has argued and presented a lot of evidence that there has been intense media coverage, and that has created such a biased environment there in Latah County that it is basically compromising his right to a fair trial. Now, the defense presented witnesses who expressed concern over the community's sentiment towards Mr. Bryan Kohberger, with some residents suggesting that there would be violent repercussions if he was acquitted. Now, the attorneys representing Bryan Kohberger, the lead attorney, Ann Taylor, emphasized the need for a change of venue to protect Bryan Kohberger's constitutional rights. Now, in contrast, the prosecutors argue that they can get a fair jury seated in Latah County, and they note that, hey, There's been extensive media coverage beyond the local community, and they also stress the convenience of keeping the trial in the area for the victims' families. The father of victim Kaylee Gonzalez, Stephen Gonzalez, has expressed confidence in the community's ability to judge fairly the case, labeling the venue change request as irrelevant. We'll have to wait and see. Anyway, Kohberger's defense has raised concerns about what they describe as a mob mentality against him there in Latah County, citing statements from local residents that suggested violence if Kohberger were acquitted. They also conducted a survey indicating that 70% of the locals believe Bryan Kohberger is guilty, further supporting their request to move the trial to a larger jurisdiction, in this case, Boise, Idaho, so that there's a larger jury pool in which to pick. Now, the trial is currently set to begin on June 2nd of 2025 after Kohberger waived his right to speedy trial. And since it is a death penalty case, there have been pretrial motions, and there will be even more pretrial motions in the coming future, which obviously take time as well. So we are all waiting for the decision of whether to change the trial venue. Obviously, it's pivotal, and it could impact whether it is perceived as a fair proceeding. We'll have to wait and see. Now, Judge is expected to announce his ruling after thoroughly reviewing the arguments from both sides. I get the fact that a crime should be tried generally where it is committed. That is a fundamental tenet in our Constitution, that a crime should be tried where it took place. However, there are exceptions to all rules. And the exception to this particular rule is that you have to have a fair jury pool. If 70% of your population has said that Bryan Kohberger is guilty, pretty good odds that, well, you're going to have to bring in a lot of jurors. It doesn't say it can't be done, but this is a death penalty case. Why risk it? I don't see what the judge is troubled about or what he is contemplating in this particular situation. I think it's rather clear. Move the trial to Boise. Don't create appellate issues. One of the things the judge has to consider, even though they may not like it, is that you have to protect the defendant's rights. And from there, then you can protect the record, which means no appeal when, in fact, he is convicted. Next on the docket, Sarah Boone. Remember the woman who's had 8 previous attorneys? Then she was proceeding pro se after she's accused of stuffing her boyfriend into a suitcase and him dying. Well, guess what? She's got a new attorney who's volunteering his time, it would appear. So a judge in Florida has refused to delay Sarah Boone's murder trial, saying that it's the defendant's, Miss Boone's, own fault that her attorney only has a month to prepare for this homicide case. Now, let's be realistic, ladies and gentlemen. This is not a factually difficult case. I could pick this case up and go try it in a month. Now, the 9th attorney to represent her on the charges, obviously that she killed her boyfriend, Jorge Torres, when he was found dead, zipped inside a suitcase after a night of a little too much drinking. Anyway, James Owen has agreed to step in to represent Ms. Boone and asked the judge to delay the murder trial until the end of this year or the beginning of 2025. He says he needs an expert to be an effective attorney. And he wants to pursue a battered spouse defense, which seems interesting since Ms. Boone was not married to the deceased. Anyway, Mr. Owens joined the case back in August 30th of last month because Boone has struggled to represent herself after the judge ruled she had forfeited her right to an attorney. Now, Mr. Owens said he plans to hire 2 forensic psychologists to serve as experts to bolster a battered spouse defense, but the deadline to file such a notice for the defense is September 7th. Now, Owen said that he has been unable to access digital evidence or go through the discovery that now sits in boxes with Ms. Boone at the jail. Now, among the experts Mr. Owen said he wants to hire is Dr. Michael Bryan, who recently testified and diagnosed Marcia Thompson with battered wife syndrome. Now, in July, a jury found Thompson not guilty of first-degree murder in the shooting death of her husband. Now, the judge refused to continue the trial, noting that the case has already been pending for 4 years, 6 months, and 4 days. He admonished that Mr. Owens was fully aware of the trial dates and deadlines when he stepped into the case and said that Ms. Boone has only herself to blame for her previous attorney's withdrawal. Now, when Mr. Owens spoke outside of the courtroom, he said that he has unsuccessfully attempted to try and negotiate a plea for Ms. Boone, but will move forward with the case despite being unable to get that continuance. I'm going to have some help, he acknowledged, and he's trying to assemble a team right now, and also noted that he was not working pro bono on the case, telling the cameras that Sarah owes me. Anyway, Sarah has no money, so I'm not sure how he's going to get paid. Anyway, Miss Boone is due back in court for a motions hearing on September 26th. Her trial is scheduled to start October 7th, and I can't wait, ladies and gentlemen. We will bring it to you live. It just gets more bizarre. If you're not getting paid and you haven't been paid, yeah, it's pro bono. Next on the docket, was there jury misconduct in the Ashley Benefield case? Well, guess what? Miss Benefield is asking for a new trial. That's right. The former ballerina convicted of manslaughter for killing her husband is asking the judge to grant her a new trial. What is the allegation? She's saying that a juror illegally smuggled a phone into the deliberations room. And Miss Benefield is obviously awaiting sentencing since the jury convicted her, but they failed to convict that she shot her husband, Douglas Benefield, in self-defense. So while she faces a potential sentence of up to 30 years behind bars, her attorneys are trying to get her a new trial, citing several issues. Now, the motion accuses prosecutors of making several improper and inflammatory remarks during their closing arguments in the case, including telling the jury that Doug had filed for sole custody before his death. In fact, it had been Ashley who had filed for sole custody before the shooting. The defense also took issue with the prosecution calling Ashley a manipulator at least 14 times and accused the state of ridiculing her emotional testimony. Now, included with the motion for a new trial is a motion to interview the jurors who convicted Ms. Benefield. Her attorneys have argued that a juror who is yet to be identified brought a cell phone into the jury room and used it to communicate while the deliberations were ongoing. Now, apparently some online user, the That Hoodie guy, made comments on a live stream of the trial during deliberations that Ashley's attorneys say there's proof that he was in communication with someone inside the jury room. In a series of messages that began 10 minutes before the parties were told there was a verdict, That Hoodie guy said, "Verdict incoming." And my sister snuck a flip phone in. She texted me 5-1 guilty, may compromise on manslaughter. 2 minutes after that message, the jury returned the compromise verdict of manslaughter. Now, defense attorney said that they also want to talk to juror 15, who is accused of lying on the questionnaire during voir dire. The juror failed to disclose her personal history with domestic violence and the fact that she is a party to a custody situation, very similar to Miss Benefield. Now, prosecutors have opposed the defense motion to interview jurors, saying nothing indicates the verdict would have been any different. Now, both sides will argue their positions in a motion hearing, which is scheduled for September 16th. That's prior to the sentencing, where Ms. Benefield will be sentenced on October 22nd. Now, clearly have a couple of issues here, ladies and gentlemen. If a juror did, in fact, have a cell phone and was communicating with somebody, my humble opinion is you get a do-over. Arguments saying that the defendant is a manipulator, misstating a fact, guess what? In closing argument, that is argument. The judge tells everybody that is argument. And if there's a discrepancy in what people say, they need to rely upon their collective judgment and their notes throughout the trial. So I think that new trial, based on anything other than a juror misconduct issue, is a no-starter. We'll see how it goes. Next on the docket, Laken Riley murder suspect says the evidence should be suppressed against him. Well, attorneys for the man accused of murdering nursing student Laken Riley in Georgia are requesting a hearing to suppress the evidence in the case. Now, Jose Ibarra was arrested back in February for the murder of 22-year-old Riley, who was killed while she was out for a run on the University of Georgia campus. Now, Ibarra's defense attorneys claim 2 cell phones, that Ibarra's social media accounts and Google data, and ultimately his DNA were seized or searched in an unlawful manner. The defense claims officers unlawfully entered his apartment without a warrant on February 23rd, and Ibarra was detained by police in the absence of probable cause. The defense claims authorities obtained a search warrant after Ibarra was detained. Now, the motion also claims that a search warrant was not based on probable cause, overly broad, and was the fruit of a poisonous tree, which is illegally obtained evidence from an unlawful search or seizure. Now, the motion also raises issues of DNA testing and fingerprints collected in this case. And the defense attorneys claim that the samples taken during Riley's autopsy did not exclude Ibarra, but also did not exclude another known individual associated with the case. Now, an indictment charges Ibarra with 10 charges of malice murder, 3 counts of felony murder, kidnapping with bodily injury, aggravated assault with intent to rape and aggravated battery, obstruction, or hindering a person making an emergency telephone call, tampering with evidence, and being a peeping Tom. Mr. Ibarra is also accused of attempting to rape Riley, asphyxiating her, and seriously disfiguring her head by striking her head multiple times with a rock. A tampering with evidence charge is for the allegations he disposed of his jacket and gloves to conceal the crime. And Ibarra is also accused of spying on a woman at an apartment at the University of Georgia Village housing complex the day that Riley was killed. Currently, he is scheduled to go to trial in November, and prosecutors are seeking a life in prison without the possibility of parole for Mr. Ibarra, who previously pled not guilty to all charges. Now, Ibarra's attorneys have also filed a motion to move the trial from Athens, Clark County because of excessive media coverage. Needless to say, that's right, the prosecution opposes that motion. We'll have to wait and see if Mr. Ibarra gets any relief on any of those motions. We'll bring it to you when it happens. Next, Robert Tellis. Remember, that's right, the former Democratic politician who was convicted last week in the murder of a journalist by the name of Jeff German. He convinced jurors he was guilty when he testified that he was framed in a broader conspiracy, according to the jury foreman. Now, Mr. Tellis was sentenced to life in prison with the possibility of parole after 20 years. Prosecutors alleged and proved that Mr. Tellis stabbed the reporter, Mr. German, to death on September 2nd, 2022, because he was angry with the journalist's reporting. Now, German had written stories critical of the Democrat and his workplace conduct, including allegations of an inappropriate romantic relationship with a female co-worker. Now, Tellis claimed that the law enforcement and his political rivals framed him in the reporter's murder, and they wanted to see him behind bars. Now, the foreman says, hey, I went back there with a very strong guilty at the beginning, the foreman said, and I just couldn't find a piece of evidence that he wanted us to find. The foreman said that fellow jurors deliberated for the better part of 3 days, reviewing testimony from about 30 witnesses and 400 pieces of evidence, including photos, videos, and the police reports. We just really wanted to just let everyone know what we really did, looking over everything from point A to point B, and we wanted him to have the best shot, the foreman told the press. I personally knew nothing about the guy, so I didn't have any bias towards him. Several jurors needed convincing that enough of the evidence pointed to Tellis, the foreman noted. One juror, he said, was initially undecided because she couldn't believe basically someone could make so many little mistakes and be that bad of a criminal. Anyway, Mr. Tellis says he unequivocally is innocent, and he gave an interview to that, which kind of goes over his trial testimony once again to a newspaper reporter while he is in custody. Now, as you may recall, Mr. Tellis said, I didn't kill Mr. German. When I share an opinion with you, that's my right, and it's your right to decide whether or not you agree with my opinion or not, whether you want to doubt the opinion. I'm just hoping that I'm not stopped from sharing what I have to share with you. Anyway, this case goes to a couple of points that we make here quite a bit. One, jurors take their jobs very seriously. They gave Mr. Tellis the benefit of the doubt, and he talked himself into a conviction. A lot of defendants want to testify. It's ultimately their decision. They can do that, but the attorney gets to say, you're going to do it against my advice. I tell you, as a defense attorney, I have one more cases where the defendant does not testify because the jurors start to look at all of the evidence to whether they simply believe the defendant's testimony. And normally they don't. There's always something bad in there. Anyway, Mr. Tellis will have at least the next 20 years before he's eligible for parole to think about his poor decision making. Next, remember that guy that jumped the bench for the judge? Yeah, take a look at this video. I love this video. Anyway, that man accused of leaping over the bench and attacking the judge in Las Vegas is, well, he's set for trial. Now, the guy's name is Deobra. Dobra? Redden, Redden. We'll just refer to him as Mr. Redden. Anyway, he faces 9 charges, including felony attempted murder of a victim over the age of 60, i.e. an at-risk adult, and he has pled not guilty by reason of insanity. So why do we have injuries here? Well, obviously, this guy, Mr. Redden, jumps over the judge's bench and tackles Judge Mary Kay Holthus, and she was bruised during the attack, which is obviously bad. Now, Judge Holthus was sentencing Mr. Redden for attempted battery charges when he jumped over the bench towards the judge. Now, according to the arrest report, the judge said that Mr. Redden knocked her out of her chair and slammed her head against the wall before ripping some of her hair out. The report stated that 2 marshals were notified of the panic alarm, but were dispatched to the wrong courtroom. Oops. Anyway, Redden's defense team and family say that he is and has been diagnosed with paranoid schizophrenia, and they have retained a criminal defense attorney by the name of Carl Arnold, who is also representing Dwayne Keefe D. Davis in the Tupac murder case. Now, Mr. Redden has a lengthy criminal history, 3 felony convictions to be exact. Anyway, his trial is scheduled to begin today, September 3rd. And finally today, our dumb criminal of the day. Please meet Teresa Heitman. Now you say, that's a nice lady, Teresa Heitman. What could she possibly have done? Well, she got a DUI. Well, Scott, anybody could probably get a DUI. First one, just didn't realize you had a couple too many drinks. These types of things could possibly happen. Well, in this particular case, Miss Heitman just happens to be the mayor of Naples, Florida. And now she's been arrested for driving under the influence of alcohol. And how did she get arrested? Well, another couple said that she followed them home and then ran over their mailbox. So there's actually a 911 call where the man reports that he and his wife were followed home by a woman behind the wheel of the silver vehicle. The caller said the woman stopped her car on the grass in front of their home. I think the mayor is drunk. And she just literally, she just drove over our mailbox, the caller can be heard saying in the 911 call. Now, the dispatcher asks, the mayor? I don't know. She's claiming to be the mayor. I don't know who she is, he responded. Then he asks her for her identity. Mayor Teresa Heitman, she replies. There's also body cam footage of the interaction where she apparently interacts with police officers. Mrs. Mayor, will you come over here? No, don't call me mayor. I am Teresa Heitman right now. I am not the mayor. Anyway, she told the police that the couple cut her off in traffic, and she apparently did the normal field sobriety test after telling them that she'd only had 1 glass of wine. Miss Heitman never admitted to drinking, ever. Anyway, they found probable cause to arrest the good mayor. She was taken to the Naples Justice Center, to jail, where she agreed to do a blood test. And guess what? The breath test, 0.155 and 0.169. So she was well over the legal limit. Anyway, she left jail on a $5,000 bond. Needless to say, the city put out the sad statement that they're saddened to learn about the incident involving the mayor. We know it's a difficult time, and we're going to give her the space that she needs. Anyway, don't worry. The city will continue their work despite their mayor being a alleged drunker. Alleged. Anyway, Miss Heitman, you are a dumb criminal of the day. You know better. You're a public official. Your job is to, do it better and cleaner than the next guy. But it just once again reduces my faith and confidence in any politician at all. all the way down to the mayor's office. All right, that's all we have for today, ladies and gentlemen. Thanks for watching. Please join us tonight, 6 p.m. Mountain Time. We'll have a guest with us this evening, my investigator, one of my investigators that I use, and join us. And remember, the Constitution matters.